day, attorney. We are the Group 3 from BSA2B. Today, we will be discussing Sections 114 to 134 of the Revised Corporation Code of the Philippines, a crucial part of the law that highlights the modernized approach to corporate governance. These sections focus on the operations of foreign corporation and closed corporations, as well as other essential provisions that ensure accountability and compliance in corporate dealings. By addressing topics like the registration and regulation of foreign businesses and the unique flexibility granted to closed corporations, these provisions aim to create a more inclusive and business-friendly environment in the Philippines. They also demonstrate our commitment to fostering economic growth while upholding fairness and integrity in the corporate sector. As we explore these provisions, let us reflect on their significance in shaping a vibrant and competitive corporate landscape. Thank you, and let's begin.
Good day, everyone. I am Ella Barrios, and I will be discussing sections 114 to 116 of the Revised Corporation Code of the Philippines, which outlines the incorporation requirements for religious organizations and the rules for forming one-person corporations or OPCs. So, let us begin. Starting with Section 114, which is all about the incorporation requirements of religious societies. A religious society, order, diocese, synod, or district organization may incorporate for the management of its affairs and properties under the following conditions. First is approval. At least 2/3 of the membership must give written consent or vote in favor of the incorporation during a meeting convened of this purpose. This requirement ensures that the decision to incorporate reflects the collective with all of the majority and promotes transparency within the organization. Second is filing with the Commission. Articles of incorporation must be filed with the Commission, verified by an authorized member such as presiding elder or secretary. This ensures that the incorporation process is formally documented and properly authorized by a recognized representative of the organization. And third is the required information. The articles must include confirmation that the organization is part of a religious denomination, sect, or church, a statement that the incorporation is not prohibited by the organization's governing rules, purpose of incorporating for administration of its affairs and properties, location of the principal office in the Philippines, and lastly, names, nationalities, and addresses of 5 to 15 elected trustees for the first year. Ensuring clarity and compliance with the legal requirements. Incorporation must comply with the rules of the religious organization and not be forbidden by competent authority. This ensures that the incorporation aligns with both internal governance and external legal standards. So, let's proceed with Section 115, which is the first section in Chapter 3, One-Person Corporation. Applicability of provisions to one-person corporations. It specifies that the rules in this chapter apply directly to OPCs, with other provisions of the Corporation Code serving as the supplementary unless stated otherwise. The provisions of this title specifically apply to one-person corporation or OPCs. Other provisions of the Corporation Code apply supplementarily unless stated otherwise in this title. Following this ensures that the rules governing OPCs are tailored to their unique structure, with additional provisions applied when necessary. And lastly, for my part, is the Section 116, which defines a one-person corporation. A one-person corporation or OPC is a corporation with a single stockholder. Only a natural person, trust, or estate can form an OPC. This structure allows for great flexibility and control, as it eliminates the need for multiple shareholders. However, certain entities are prohibited from incorporating as an OPC, including banks and quasi-banks, pre-need trust and insurance companies, publicly listed companies, and lastly, non-chartered, government-owned and controlled corporations. This restriction ensures that only appropriate organizations can adopt the OPC structure, maintaining regulatory control over sectors that require broader oversight. Additionally, a natural person licensed to exercise a profession cannot form an OPC for professional practice unless allowed by special laws. This restriction ensures that regulated professions adhere to the necessary legal frameworks and maintain high professional standards. It also prevents conflicts of interest and ensures that professional complies with industry-specific regulations designed to protect public welfare. And that's it for my part.
Good day everyone, I am Alamos Christine Bello, and for this part, I'll be discussing sections 117 to 119 of the Revised Corporation Code of the Philippines, specifically focusing on the one-person corporation or OPC. So this type of corporation is a game changer in Philippine corporate law because it allows a single individual to establish a corporation without needing business partners or co-owners. My goal is to explain the key points, simplify the technicalities, and provide examples to help you better understand. So, let's start with Section 117, which addresses the capital stock requirements for an OPC. Unlike traditional corporations that often have a required minimum capital stock, OPCs do not have to comply with such a requirement. This makes it easier for small business owners or entrepreneurs with limited resources to start their ventures. However, there are exceptions for industries governed by special laws. For example, if an individual wants to open a bank or an insurance company as an OPC, the law might require a specific minimum capital stock to ensure the business has enough financial capacity. Overall, this provision is designed to make entrepreneurship more accessible to individuals who want to take advantage of the corporate setup without needing large investments upfront. Now, here in Section 118, which discusses the Articles of Incorporation for OPCs, which serve as the legal document that establishes the corporation, like other corporations, OPCs must comply with the general requirements stated under Section 14 of the Revised Corporation Code of the Philippines. However, there are additional details specific to OPCs. If the single stockholder is a trust or state, the articles must include the name, nationality, residence, and proof of authority of the person managing the trust or state. For example, if the single stockholder is a deceased person's state, the executor must provide legal documents providing their authority. Additionally, the Articles of Incorporation must name a nominee and an alternate nominee. These individuals will take over the management of the OPC in case the single stockholder becomes incapacitated or passes away. Their rules, authority, and limitations should also be clearly defined. For instance, if the sole stockholder of an OPC is unavailable due to medical reasons, the nominee can temporarily make decisions on behalf of the corporation to ensure continuity of the operations. So now in Section 119, which simplifies the requirements for OPCs by removing the need for corporate bylaws, in traditional corporations, bylaws are used to establish rules for how the corporation is run, including guidelines for meetings, decision-making, and the roles of stockholders and directors. However, because OPCs have only one stockholder, there is no need for such formalities. For example, in a regular corporation, bylaws must state how many directors are needed to approve decision, or to specify how decisions are voted on during board meetings. In contrast, an OPC doesn't require this because the sole stockholder has full control over corporate decisions. This feature highlights how the OPC structure is streamlined and less burdensome compared to traditional corporations. To make these concepts more relatable, let's consider an example. So Maria wants to open a boutique as an OPC. Thanks to Section 117, she doesn't need to meet a minimum capital stock requirement, making it easier for her to start her business. Under Section 118, Maria's Articles of Incorporation will name her as the sole stockholder. She will also need to designate a nominee, let's say her sister Anna, who can temporarily take over if Maria becomes unavailable. This ensures that the business can continue operating even in unforeseen circumstances. And finally, under Section 119, Maria doesn't need to draft corporate bylaws because she is the sole decision maker for her boutique. This example shows how the OPC framework is designed to be simple and practical for individuals. In conclusion, the one-person corporation or an OPC is a significant innovation in Philippine corporate law. It allows individuals to create corporations without the complexity of multi-stockholder setups. Section 117 removes the burden of a minimum capital stock requirement, making entrepreneurship more accessible. Section 118 ensures clarity in business succession through the Articles of Incorporation. And lastly, Section 119 simplifies the setup by removing the need for corporate bylaws. And this framework empowers individuals to formalize their business while minimizing paperwork and legal complexities. And thank you for listening, and I hope you now have a better understanding for sections 117 to 119. And that would be all. Thank you.
Hello everyone, I'm Jodeline Sharon Igarciano, and today I will talk about Section 120 to Section 122 from the Revised Corporation Code of the Philippines. Let's start with Section 120. Section 120, Display of Corporate Name. This section mandates that a one-person corporation or OPC clearly indicates its nature as an OPC by including the letters OPC in its corporate name. This requirement ensures transparency and compliance with corporate naming standards. The letter OPC can be positioned either directly below the corporate name or appended at the end of the name. For example, if a business owner chooses to register the name Future Tech Solutions, the corporate name should indicate its OPC status as either Future Tech Solutions OPC, where the OPC is at the end of the name, or Future Tech Solution and then OPC under its name. That's all. Section 121, Single Stockholder as Director and President. So in a one-person corporation or OPC, the single stockholder is automatically designated as both the sole director and the president of the company. So this provision aligns with the unique nature of an OPC where the ownership and management are consolidated into one person. So for the sole director, it is responsible for the overall governance of the company, while the role of the president involves overseeing the day-to-day operations. By combining these roles, the law simplifies corporate structures and an administrator for OPCs. So for example, suppose Jane Doe registers Bright Innovation OPC as her company. As the sole stockholder, she will hold two primary roles by default. So the number one is a sole director. She governs the company, makes strategic decisions, and represents the company legally. Number two, she manages the company's daily operation and ensures its activities align with its goals. So, no other individual can serve as the director or the president in her place unless the stockholder changes. Section 122, Treasurer, Corporate Secretary, and other officers. This section outlines the requirements for appointing corporate officers in an OPC. Appointment timeline should be within 15 days of receiving its certificate of incorporation. The OPC must appoint its treasurer, corporate secretary, and any other officers deemed necessary for operations. So the company must then notify the Security of Exchange Commission or SEC of these appointments within 5 days. Restriction on single stockholder. The single stockholder cannot serve as the corporate secretary. This role must be assigned to someone else to ensure proper checks and balances in the corporate structure. However, the single stockholder can serve as the treasurer. Additional requirements for the stockholder treasurer. If the stockholder assumes the role of treasurer, they must submit a surety bond to the Securities and Exchange Commission or SEC. The stockholder must also sign an undertaking to manage the company's funds responsibly and in accordance with the Article of Incorporation approved by the Securities and Exchange Commission or SEC. The surety bonds must be renewed every 2 years or as frequently as the Securities and Exchange Commission or SEC requires. So this regulation emphasizes accountability and safeguards to the financial interest of the one-person corporation or OPC. For example, John Smith establishes Smart Ventures OPC and decides to appoint himself as treasurer. He also appoints Maria Cruz as the corporate secretary. As required by law, within 15 days of incorporation, these appointments are made, and John notifies the Security and Exchange Commission or SEC within the subsequent 5 days. As treasurer, John submits a surety bond and commits in writing to manage the company's funds responsibly. This ensures compliance with regulations and builds trust with stakeholders. John must renew the bonds every 2 years or as required by the Securities and Exchange Commission or SEC. So this structure ensures a balance of roles while maintaining oversight and financial integrity in the OPC. That's all for Section 120 to 122. Thank you.
Everyone, I am Jacqueline K. Nopuente and I will be discussing Sections 123 to 125 of Revised Corporation Code of the Philippines. So let's start with Section 123. The Corporate Secretary is the one who keeps all the official records of the corporation, like meeting notes and other important documents if the single owner of the OPC dies or becomes unable to manage the corporation. The Secretary must inform the nominee or alternate nominee, the people chosen by stockholder to take over in emergencies within 5 days. Notify the SEC or Security and Exchange Commission about the stockholder's death and give the details of their heirs, family members who will inherit the stockholder shares. Arrange a meeting with the nominee, alternate nominee, and heirs to decide what to do next, like electing a new director or making changes to the corporation. So next section is Section 124, Nominee and Alternate Nominee. The nominee and alternate nominee are the backup managers chosen by the stockholder. These roles are very important because they ensure the corporation can keep running even if the stockholder dies or is unable to continue. The stockholder must include their nominees' names in the Articles of Incorporation, the document that officially forms the corporation. The nominees must agree to take on this role by signing a written consent. The nominees can change their minds and withdraw their consent anytime. So last section is Section 125, Term of Nominee and Alternate Nominee. This section explains how long the nominees are in charge if something happens to the stockholder. Temporary incapacity. If the stockholder is sick or unavailable, the nominee runs the corporation until the stockholder can return. Second is death or permanent incapacity. The nominee manages the corporation until the heirs decide who will take over the ownership, either one of the heirs or the estate itself. If the nominee can't do the job, the alternate nominee steps in and takes over with the same responsibilities. And that's all for my part. Thank you.
Good day everyone, I am Mariela Kate M. Sales and I'm here to discuss Sections 126 to 128 of the Revised Corporation Code of the Philippines that is focusing on their implications for one-person corporations or OPCs. These provisions emphasize flexibility, accountability, and efficiency in OPC operations. So let's start with Section 126, Change of Nominee or Alternate Nominee. Section 126 allows the single stockholder of an OPC to change the nominee and alternate nominee at any time without the need for any formal amendments to the Articles of Incorporation. The process involves submitting the names of the new nominees along with the written consent to the Securities and Exchange Commission or SEC. So, to understand this, we need to remember that a nominee is someone designated to take over the corporation in the event of the stockholder's incapacity or death. The alternate nominee serves as a backup if the primary nominee cannot act for any reason. This is especially critical for ensuring that the corporation can continue functioning smoothly even in the absence of the original stockholder. The main purpose of this section is to provide flexibility for the stockholder. Given the changing nature of business and personal circumstances, this provision ensures that the single stockholder can easily make adjustments to the nominees, which helps to safeguard the corporation's operations. Furthermore, the no amendment requirement simplifies the process, avoiding unnecessary bureaucracy. So, I will give an example for this section. So, let's say that Bianca is a single stockholder of an OPC called Bianca's Technological Services Incorporation. Initially, Bianca nominates her cousin Gabriel to act as her nominee and her friend Kenneth as the alternate nominee. But, a few years later, Gabriel moves abroad and is no longer able to fulfill her duties as the nominee. So, Bianca decides to nominate her business partner Lian to take over. So, Bianca just simply needs to submit the new nominations along with the written consent of Lian and Kenneth to the SEC, and again, no need to amend the Articles of Incorporation because the law allows for such changes to be made simply by notifying the SEC. This is a practical solution for business owners who may experience personal or professional changes, as it avoids the hassle of going through complex processes like amending foundational documents. So let's move on to the Section 127, Minutes Book. Section 127 mandates that all one-person corporation must maintain a minutes book. This minutes book should record all actions, decisions, and resolutions taken by the corporation. In an OPC, there are no formal meetings with multiple stockholders, so the minutes book serves as the official record of corporate decisions made by the sole stockholder. This requirement may seem a bit unusual since there is only one stockholder, but it ensures accountability and transparency. A business owner may not think it's necessary to keep records since they are the sole decision maker. But having a minutes book is vital for several reasons, such as ensuring legal compliance and providing a preference in case of future audits or disputes. So, the main purpose of this minutes book is to keep track of the business decisions made by the stockholder. It serves as an official record that can be referred to in the future, particularly during audits, compliance checks, or even in the legal proceedings. Having a clear documentation can protect the corporation from accusations of misconduct or improper business practices. So, example, let's say again Bianca decides to approve a significant purchase for her OPC, such as buying a new office building for her growing business. And Bianca documents the decision in the minutes book by writing a formal record that includes the price of the office, the reason of the purchase, and the terms of the transaction. Bianca signs the dates that entry, ensuring that it's properly recorded. So in this case, if a third party, such as a bank or a tax authority, needs to verify the legitimacy of the transaction in the future, Bianca can easily point to the minutes book as evidence of the decision. This is specifically important if there are any questions about the corporation's financial decisions or the use of its asset. So, let's move on to Section 128, Records in lieu of meetings. Section 128 essentially allows the stockholder to take action without holding a formal meeting. Instead of having to physically meet, a written resolution signed and dated by the stockholder will suffice. This resolution must be recorded in the minutes book, and for legal purposes, the date when it is recorded will be considered the official meeting date. This provision is a practical solution for single stockholders who might find it time-consuming or unnecessary to convene for meetings, especially when they are the sole decision maker. It makes business operations more efficient by reducing administrative work. The main purpose of Section 128 is to make corporate decision-making in an OPC more efficient and less formal. It removes the need for unnecessary paperwork and meeting logistics while ensuring that the decisions of the stockholder are formally documented. So for example, suppose that Bianca decides to declare a dividend for her OPC. Instead of calling a meeting or writing up detailed meeting minutes, she simply drafts a written resolution that states, I, Bianca, the sole stockholder of Bianca's Technological Services Incorporation, hereby declare a dividend payment of 500,000 to be paid to myself as the sole stockholder. The payment is to be made from the company's retained earnings. So, Bianca signs and dates the document and then records it in the minutes book. The moment she records it in the minutes book, it is considered the official meeting date for all purposes. This reduces the need for formal meetings, which can be particularly beneficial in situations where time and efficiency are important. So in summary, Section 126 allows for easy changes to the nominees, ensuring the smooth transition of authority in case of unforeseen circumstances. Section 127 ensures that there is a record of all important decisions, which enhances transparency and accountability. Sections 128 simplifies decision-making by allowing resolutions to be written and signed rather than requiring formal meetings, which makes the business operation of an OPC far more streamlined. This provision offers a balance of efficiency and legal compliance, allowing single stockholder corporations to operate smoothly without the complex requirements typically associated with traditional corporations. And by following these provisions, a single stockholder can make decisions quickly and effectively, ensuring the continued success of their business while maintaining proper legal documentation and accountability. So that's it for my part. Thank you.
Good day everyone! I am Ivan Carsorera. Today, I will be discussing some important provisions of the Revised Corporation Code of the Philippines, specifically Sections 129 to 131, which deals with the reportorial requirements for OPCs, the liability of the single shareholder, and the conversion of an ordinary corporation to an OPC. These sections are crucial for understanding the responsibilities of an OPCs and how they operate within the legal framework. Let's start with Section 129, which outlines the reportorial requirements for a one-person corporation, which has 4 subcategories. First, the annual financial statements. OPCs are required to submit annual financial statements audited by an independent certified public accountant. However, if the OPC's total assets or total liabilities are less than 600,000 pesos, the financial statements must be certified under oath by the corporation's president and treasurer instead of being audited by CPA. Second, the explanation and comments from the President. The President of the OPC must also submit a report that explains any qualifications, reservations, or adverse remarks made by the auditor in their report. This ensures transparency and provides clarity on any issues raised during the audit. Third, disclosure of self-dealing and related party transactions. Another key requirement is the disclosure of all self-dealing and related party transactions between the OPC and the single stockholder. This is critical for ensuring that there are no conflicts of interest or improper dealings that could harm the corporation or its stakeholders. And lastly, the other reports. The SEC may require additional reports as deemed necessary. This could include any other forms of documentation or information needed to maintain compliance with the law. Failure to submit these reports 3 times, whether consecutively or intermittently within a 5-year period, can lead to the OPC being placed under delinquent status. This highlights the importance of timely and accurate reporting for OPCs. Moving on to Section 130, which addresses the liability of the single stockholder in an OPC. An OPC, by its nature, is designed to offer limited liability to the single stockholder, meaning that the stockholder's personal assets are generally protected from the corporation's debts. However, the stockholder must affirmatively show that the corporation is adequately financed and that its property is independent of the stockholder's personal property. If the stockholder fails to prove this distinction, the stockholder will be jointly and severally liable for the corporation's debts and liabilities. In other words, if the OPC's assets are not sufficiently separate from the stockholder's personal assets, the stockholder may be held personally responsible for the debts of the OPC. This is an important safeguard because it ensures that the principle of limited liability does not allow individuals to misuse the corporate structure to avoid personal responsibility. Pursing of the corporate bail. A legal concept that disregards the separate legal entity of the corporation applies to OPCs just as it does to other types of corporations. This means that if the corporation is used for fraudulent purposes or improper personal gain, the stockholder could not be held personally liable. Lastly, let's look at Section 131, which governs the conversion of an ordinary corporation into a one-person corporation. An ordinary corporation which has multiple shareholders can convert into an OPC if a single stockholder acquires all the corporation's stock. This can be done by applying to the SEC for the conversion, provided that the corporation submits the necessary document as required by the Commission. Once the conversion is approved, the SEC will issue a certificate of filing of amended articles of incorporation, reflecting the new status of the corporation as an OPC. It's important to note that once converted, the OPC will succeed the ordinary corporation and be legally responsible for all the latter's outstanding liabilities as of the date of conversion. So this means that the OPC inherits all the financial and legal obligations of the previous corporations, ensuring continuity and accountability. So to sum up, Sections 129 to 131 of the Revised Corporation Code, it provides clear guidelines for reporting requirements, shareholders' liability, and conversion procedures for one-person corporations. These provisions help ensure that OPCs operate transparently, maintain proper financial management, and uphold the legal and financial responsibilities of their shareholders. That sums up my part. On to the next reporter.
I am Kisha Maydinua, and now I will be discussing Sections 132 to 134 of the Revised Corporation Code of the Philippines. These sections deal with the important processes concerning corporate conversions and dissolutions, which are critical to understanding the life cycle and flexibilities of corporation. Let's delve into each sections in detail. Now let's begin with Section 132. This section explains how a one-person corporation or OPC can be converted into an ordinary stock corporation. The process starts with the OPC notifying the Securities and Exchange Commission or SEC about the circumstances leading to the conversion. This must be done within 60 days of the event prompting that change. The corporation must then comply with all requirements set forth in the Corporation Code for stock corporations, as well as any additional rules the SEC may prescribe. Once the OPC fulfills the requirements, the SEC will issue a certificate of filing of amended articles of incorporation, which officially reflects the conversion of the OPC into an ordinary stock corporation. Now, let's consider what happens in the event of the death of the single stockholder. In such a case, the nominee or alternate nominee of the OPC is required to transfer the deceased shares to the legal heir or estate. This transfer must take place within 7 days and it must be supported by legal documents such as an affidavit of heirship, a self-adjudication document if there is a sole heir, or other similar legal documentation. After the shares are transferred, the legal heirs must notify the SEC within 50 days to inform them of their decision regarding the future of the corporation. They have two options. First is wind up and dissolve the OPC, or second, convert the OPC into an ordinary stock corporation. Importantly, if the OPC is converted, the resulting ordinary stock corporation assumes all the liabilities and obligations of the OPC as of the date of the conversion. This ensures that the right of creditors and other parties remains protected. In summary, Section 132 ensures that OPCs have a clear structured pathway for conversion or succession, especially in cases of unforeseen events like the death of the sole stockholder.
Next, we move to Section 133, which outlines the various methods by which a corporation may be dissolved. Dissolution can be categorized into two types, the voluntary and involuntary. Let's first talk about voluntary dissolution. This occurs when the corporation itself initiates the process. There are several ways to do this. First, by a resolution adopted by the board of directors or trustees and stockholders or members if creditors are not affected. Second, through SEC judgment after a hearing, in cases where creditors are affected. The SEC ensures that creditors' rights are protected before approving the dissolution. The third is by amending the articles of incorporation to shorten the corporate term. The fourth is, in the case of corporation sold, by submitting a verified declaration of dissolution to the SEC. Fifth, lastly, the dissolution may occur as a part of a merger or consolidation. Now let's discuss involuntary dissolution, which occurs when external events or legal actions terminate the corporation's existence. Some examples include the expiration of the corporate term stated in the Articles of Incorporation, legislative action specifically dissolving the corporation, a court order issued to dissolve the corporation, failure to formally organize and start operations within 5 years of incorporation. Fifth is becoming inactive for 5 consecutive years, leading to delinquent status. In this case, the SEC provides a 2-year window for the corporation to resume operations and comply with regulatory requirements. Failure to do so results in the revocation of corporation certificate of incorporation. Sixth is finally, the dissolution may occur through an SEC order based on existing laws. The process ensures that dissolutions, whether voluntary or involuntary, are carried out with proper oversight, protecting both the corporation stakeholders and the public. Finally, let's dive into Section 134, which provides the steps for voluntary dissolution where no creditors are affected. The process begins with a meeting of the board of directors or trustees, called specifically to vote on the dissolution. This is followed by the stockholders or members casting their vote. To ensure transparency, notice of this meeting must be given to each stockholders or member of record at least 20 days before the meeting. The notice can be delivered personally by registered mail or by any method specified in the corporation's bylaws. Additionally, the notice must be published in a local newspaper where the principal office of the corporation is located. If there is no local newspaper, the notice must appear in a newspaper of general circulation in the Philippines. Once the dissolution is approved by the Board of Stockholders, the corporation must file a verified request for dissolution with the SEC. This request must include the following. First, the reason for dissolution. The second is details about how and when the notices were distributed. The third is the names of the stockholders, directors, members, and trustees who approved the dissolution. The fourth one is the date, time, and place of the meeting. Fifth is proof of publication. The corporation must also submit a copy of the resolution authorizing the dissolution certified by a majority of board and countersigned by the corporate secretary. The SEC will review the request, and if no objection are raised or the request is not withdrawn within 15 days, the SEC will issue a certificate of dissolution, marking the official end of the corporation. It is important to note that for certain entities such as banks, insurance companies, or other financial intermediaries, the SEC requires a favorable recommendation from the appropriate regulatory agency before approving the dissolution. This section underscores the importance of transparency and accountability in the dissolution process, ensuring that all necessary steps are taken to protect stakeholders. 132 to 134 highlight the flexibility and safeguards within the revised corporation code. These provisions ensure the corporation can transition or dissolve in an orderly and fair manner, whether it's converting an OPC, voluntary dissolution, or following strict legal grounds for involuntary dissolution. The code provides clear guidelines for corporate governance and accountability. As we wrap up our group presentation, let me take a moment to reflect on the journey we've taken together through Section 114 to 134 of the Revised Corporation Code of the Philippines. Starting with the provision on stock corporations, all the way to the processes for corporate conversions and dissolution. Our group has aimed to provide a clear understanding of these crucial topics. This section collectively highlights the dynamic nature of corporate governance in the Philippines, ensuring that businesses operate effectively while maintaining accountability and protecting the rights of stakeholders. As the final presenter for Group 3, I hope to emphasize the importance of these legal frameworks and fostering a stable and fair business environment, whether it's managing shares, addressing liabilities, or transitioning and dissolving corporation. These provisions reflect how the law adapts to the evolving needs of business and society. We hope that our group discussion has provided valuable insights and a comprehensive understanding of the topics covered. These are not just rules in a book, they are principles that influence the real-world operations of companies, protect stakeholders, and uphold the integrity of our corporate system. On behalf of Group 3, I want to thank everyone for your attention and your engagement throughout our report. We've worked hard to break down these complex topics into something meaningful and relevant, and we're honored to contribute to your learning today. Thank you and congratulations to everyone for being part of this productive discussion. Have a great day.